This is the second in a series of videos that is providing an overview of the Wales safeguarding procedures as they apply to children at risk of harm. This series of videos is not only setting out the key stages of the procedures, but also exploring the practice changes, the cultural changes that need to come with the application of these new procedures. Running hand in hand with this video is an additional video that provides a demonstration of this part of the Act, of this part of the procedures, using the app itself. Section 2 of the procedures deals with the duty to report a child at risk of abuse, neglect, and/or harm. The duty to report simply means a responsibility to make a referral to social services whenever there are concerns that a child is experiencing abuse, neglect, or harm, is at risk of experiencing abuse, neglect, or harm, and has needs for care and support. So we are seeing not only a change in terminology from a referral to a report, but with that comes new, different additional responsibilities. So it's where we have concerns that a child is meeting the definition of a child at risk as described in the safeguarding procedures. In terms of what we mean by a concern, there may be circumstances where there isn't always evidence of abuse, neglect, or harm. It could be that you suspect rather than know that as a person is It may be that you suspect rather than know that a child or young person is experiencing or is at risk of experiencing abuse, harm, or neglect. This might be based on information from different sources, your own professional judgment, or seemingly insignificant information that may well be part of a bigger picture. These situations, even where there is no clear factual evidence, are referred to as concerns. So where will these concerns be raised? What are the sources of the concern? It could be that you are alerted to a concern about a child or a young person by a member of the general public. All practitioners have a duty to report any concerns that are alerted to them by the general public, and this applies in both work and private lives. If a member of the public tells you about a concern, either in your work or personal life, you have a duty to report the concern to social services. Again, this is a concern that there is a child at risk of abuse, harm, or neglect. The procedures clearly set out that when this concern is raised with you, you must tell the person raising the concern that you have a duty to report them, to report the concerns. That you record exactly what is said, recording all the information provided, and establishing what evidence the person sharing the concern has. You are asked to encourage them to provide their contact details, but you may need to explain to them that they can remain anonymous if they want to. However, this may not always be possible, and within the procedures are the details that set out the circumstances where this may not always be possible. What is important to emphasize is that you must not leave it to them or advise them to contact social services themselves. It may be that a child themselves makes the disclosure. So a child may make an allegation to a practitioner that they have been harmed, abused, or neglected, or they are aware of another child who may be or is being abused, harmed, or neglected. It's important to recognise that children may be letting us know about their experiences or what they are aware of for other children and people through a number of different forms. It could be that they tell us verbally. It could be that they're telling us through play, pictures, their behaviour. This really emphasises how important it is that we are actively observing children and young people. When a child makes a disclosure, it is not an easy situation to deal with. And within the procedures, there are practice guides, information, questions, pointers to consider around managing a disclosure made by a child. The key messages within these resources is that you firstly keep the child safe. Only ask open questions relevant to what the child is telling you. It is not your role to investigate the disclosure at this point. You are gathering the relevant information. Listen and observe what they're telling you, showing you, sharing with you, keeping an open mind. It's important that you do explain to the child or young person the actions that need to be taken, but in doing so that you do not make them any promises. So when managing a disclosure, either by a member of the general public, a neighbour, a friend, the child themselves, you must report those concerns immediately to your line manager and or the designated safeguarding person in the organisation. Ensure that those concerns are reported immediately to social services and record without delay and within a maximum of 24 hours what you've been told using the person's exact words, the circumstance in which the disclosure was made, the date, time, place, and people who were present, and be sure to separate fact from opinion. The procedures also set out the requirements that are placed on us in relation to seeking an individual's consent to make a report. It's important to note that the interests of the child at risk of harm must be the overriding consideration when making the decision as to whether to seek child and or parental consent prior to making the report to social services. The procedures do state that practitioners should try and seek consent from the parents, because this is more likely to lead to engagement in the safeguarding process and to child-centred outcomes, and is more likely to promote an effective working partnership with the family. The procedures are also clear that where children are deemed competent, they should also be consulted and their consent obtained. It is important that we engage children in the process as early as possible in order to ensure that their wishes and feelings are taken into consideration and to avoid them becoming the object of concern. If the child or the parent objects to the report being made, we need to make sure that we are taking into consideration their feelings when we are making those decisions as to whether we will proceed to make that report or otherwise. So when gaining consent from a parent or a carer, it's important that we do aim to get this consent unless it would increase the risk of harm to the child and or any other individuals. You must discuss with your organisation's designated safeguarding person whether you feel it's appropriate to get their consent. And when getting or seeking the consent of the parent, explain why you need to share the information, with whom and how it will be used. Check that the information that you have and that you will be sharing is accurate, up to date and proportionate. Explain to them how you will share and store that information, and outline to them what could happen if they don't give their consent. And always make sure that they are clear about the next steps that will be taken. If the parent or carer refuses to give consent, you can still make a report if you feel you need to. There may, however, be circumstances when it's not appropriate to seek parental consent. The procedures set out the following circumstances when it may not be appropriate to do so, which includes seeking consent will place the child at further risk, The child could be threatened or coerced into silence. There's the risk that important evidence could be destroyed or lost. It may be that the parent or the carer themselves is the alleged abuser. It could be that the child, who is the source of concern, is actually competent and does not want the parent to be involved at this stage. It could be that it is in the public interest that you do not seek parental consent. And again, a reminder, it's important that you discuss with your designated safeguarding person the appropriateness of seeking consent from a child or a parent. Within practice, we are operating to the General Data Protection Regulations. And whilst this does give individuals greater control over their own personal data, it does not give them the right to prevent agencies sharing information if there are concerns about a child at risk. And if not sharing the data would likely cause serious harm to the physical or mental health of the child themselves or another individual. So if you find yourself in the position that you are making a report without consent from the parent, you must do the following things. Record the reasons for this. Inform social services that consent has not been given and the reasons for this. And inform the parent that a report has been made despite their wishes, unless the decision's been taken not to seek their consent in the first instance. So this third bullet point is important for anybody making a referral without the consent of the parent to note. It is also important when considering concerns we may have about children and young people and how they are identified, how they are raised and shared, that we do not ignore or dismiss suspicions about anyone who may be abusing, neglecting or causing harm to a child at risk. This includes concerns we may have about another practitioner or colleague, a professional, paid carer or volunteer. It also extends to our private life, and this is a new element within the procedures. So we may have concerns about the behaviour of a friend, family member, neighbour, who is also a practitioner, whose behaviour, whose activities cause us to be suspicious that this is abusing, neglecting or causing children to be at risk. You are expected to report those concerns to social services, and Section 5 of the Wales Safeguarding Procedures covers the process that is to be followed in relation to concerns about a professional, carer or volunteer. So the concern has been raised, it's been shared, either shared with you or it's an observation that you have noted yourself. If you're hesitant or unsure, it is important that you first seek advice from the agency's designated safeguarding person. Do not wait for any further evidence to confirm or refute these concerns. It could, however, be that you need to contact social services directly. And you will contact social services directly if somebody would be at risk by the delay of you contacting the designated safeguarding person first. The designated safeguarding person has not taken action and you are still concerned. Or the concern is about or involves the designated safeguarding person themselves and there is no other manager to contact. The procedures also make clear that if you don't know whether to report concerns, you should always seek advice from social services to share those concerns and to get advice on what to do next. However, it is important to recognise that seeking advice does not mean you've made a report. You are responsible for making the report to social services, and if during a discussion with social services where you've contacted them in order to get some advice, if during that conversation you determine that you need to make the report, then you need to tell them. but you must follow this up in writing with a formal report. So telling social services about your concerns does not mean you have made the report that is required. So how do we make the report? Before we get there, a reminder of the stages that we need to consider before the report is formally submitted to social services. When a safeguarding concern arises, the first stage is to discuss those concerns with your designated safeguarding person and to document any concerns that you may have. Again, within the procedures, it details the information that needs to be documented in relation to your concern. During the conversation, you may well, however, determine that on the basis of the information, there is no further action to be taken. It may be that you identify that there is a role for your organisation to play and that you can provide services in order to prevent problems from escalating, in order to prevent the child being placed in a position of risk. In either of these instances, you must record the rationale for that decision when recording your discussion. It may be that on consideration of the information you have, you identify that a child may have potential care and support needs. In this instance, you will make a referral to social services for a care and support needs assessment. So it is a referral to social services in relation to care and support needs. If, however, you determine that your concerns are at a sufficient level that you are concerned that this is a child at risk as per the procedures, then you are required to report that to social services. So we see the distinction now between a referral to social services and a report. The referral is in respect of care and support needs. The report to social services is in regard to any concerns you have about a child at risk of abuse, neglect, and/or harm. When gathering information to make the report, it's important that you explain your concerns and the evidence to support those, that you provide as much specific detail and evidence as is possible, that you're honest about any factors that might influence your report, that all relevant issues about the concern are documented, and that you make clear whether the child or family have had any other form of assessment or support provided. It is important to note that at this stage you are not being asked to investigate any further. It is gathering information. So the report that is required must be made formally and in writing. The procedures clearly state the information that needs to be included in the safeguarding report to social services, which includes basic information about the child and their situation, the cause for concern that you have, relevant proportionate information to provide insight into the child's circumstances. Within the procedure, there is more detail with examples of information to be provided in relation to these specific bullet points. If making a report to social services in respect of a child at risk, you must use the report forms provided by the local authority. And if you initially made the report by phone, you must confirm this in writing using the report form within 1 working day. However, it is important to remember that the safety of the child at risk is always paramount. And if you have any immediate concerns, you should not delay in taking action. So the report is submitted to social services. They are required to acknowledge your report and reply within 7 working days. And in doing so, they will repeat the key points contained within that report. They will check the evidence that you have provided, and they will look to establish who else knows that the report has been submitted. As the person making the report, at this stage, you should be prepared and willing to potentially then go on to contribute to a strategy discussion or meeting, Assist in a Section 47 inquiry to establish whether the child is suffering or likely to suffer significant harm. Attend an initial child protection conference, and with that attendance to provide a written report, and be prepared and willing to contribute to further assessments. And the detail of those activities are covered in the remaining parts of the procedures. As the report maker, it is important to note that if you have not received an acknowledgement from social services within 7 working days, you have a duty to follow up that report. You must record the outcome of any discussion with social services and the resulting decision. If no further action is to be taken by social services, and they do not intend to advise the child or family, then you must advise the child and family of any other support that may be available. If you remain concerned about a child, you must inform your own line manager and the designated safeguarding person within your organisation, and/or bring it to the immediate attention of the senior manager within social services with responsibility for safeguarding. The responsibility around raising and reporting those concerns sits with you as the individual practitioner. So, to bring section 2 to a close, again, a reminder that the procedures are bringing about a significant shift in culture and practice. We are moving from the making of a referral to social services about concerns of a child at risk to a report to social services about concerns. We're moving from a primary focus on the risk and not necessarily on the child to a position where the child at risk is central to all decision making, with a strong focus on improving their daily lived experience. We're moving from some reluctance to obtain consent from the parent to consent being actively sought from the parent and the child or young person where it's appropriate to do so. And that we see a move from social services holding the sole responsibility once that referral is made to them to ongoing responsibilities of the person making the report.